The first thing you want to do is find a good attorney to represent you. One who has the knowledge of arbitration and one who has an understanding of the securities laws. You can have one but not the other and not really be very successful in this. Arbitration is to the law what mud wrestling is to sports. It's not like anything you find in textbooks. It's more of an art than a science, and you want to find somebody that understands that arena. I've probably done upwards of 150 securities arbitrations, mostly on the defense side because I've spent most of my career representing brokerage firms and brokers, which, by the way, has given me a pretty keen understanding of what they do and what they do wrong. So the way that you go about this typically is you may have an attorney lodge a complaint on your behalf with the brokerage firm. And this would be a letter saying that I represent this person and I'd like you to send me the statements, the correspondence, everything that you would have received in the normal course, they're obligated to provide in response to that complaint. Sometimes that will initiate a dialogue where you may have an ability to resolve something on a relatively quick basis. But oftentimes the brokerage firms will be more reticent and you'll need to go to the next step. The next step is filing a statement of claim with FINRA, which is the forum by which all disputes in the securities industry get resolved. When you open an account with your broker, you sign an agreement which specifies that any dispute will be resolved in FINRA arbitration, and the brokerage firm and broker are obligated by their membership with FINRA to arbitrate any claims that arise. So the first phase would be to file a statement of claim which lays out the dispute and indicates what the damages are and what the basis for those damages are. And it's a process. FINRA serves that statement of claim on the broker. You can choose whether you name the individual registered representative that you deal with or not, and that's a strategic call sometimes. They have a certain amount of time to respond, and from that point, there's a selection process for arbitrators. You schedule the ultimate hearing date, and then you work back determining dates for discovery and things like that. There are no depositions in arbitration, but you do have the ability to ask for discovery. And this is really oftentimes where cases are won and lost, where you get information, whether it's emails or account records, that can sometimes be the difference in the case. And the brokerage firms are what's called self-regulatory. The securities industry is a self-policing industry, which means that the brokerage firms have an obligation to supervise the activity that goes on in their branch offices. That obligation typically falls upon the branch manager. And brokerage firms can be liable for what's called failure to supervise. In almost every case that I've handled that deals with issues arising out of a customer's account, there's always an issue as to whether or not the manager was negligent in supervising the activity of the broker, and that could be a very important aspect of recovery. Now, arbitration is not for the faint of heart. You go through a hearing, you're cross-examined, and we get to cross-examine the other side, and you have to be prepared for that. I have a particular method that I think is particularly effective in getting people ready for that process. I won't tell you what it is because I don't want to give it away, but there are other attorneys who have seen that and have copied it because I think it works particularly well. In any event, it's also an interesting process because the arbitrators get to make the decision. They don't have to follow any rules of civil procedure or evidence or anything like that. They can actually and literally get the law wrong, and there's no avenue of appeal. That's why I say it's more of an art than a science. And because of that, most cases these days go to a process called mediation before the arbitration hearing commences. And mediation is a very effective way for settling cases. Both sides agree it's a voluntary process, and you pick a mediator who is an intermediary, a neutral, who's done many, many of these, and they hear both sides, and they tend to go back and forth almost in a manner like shuttle diplomacy, taking back and forth offers, encouraging the parties in one direction or another. And very often you arrive at a resolution where if you're a little unhappy and the other side's a little unhappy, you've probably gotten to the right result. So that's the process that, in a nutshell, of resolving disputes with your brokerage firm. Now, if you're looking for somebody to assist you, look for somebody who has the talent and experience to navigate through these complex waters. Look for someone like myself who can help you through that process to success. My number is 561-544-8144.